computer audio. Make that bigger for the time being. And down and zoom out a little bit. View. Admit. All right, so evidence. All right. Yeah. Oh yeah. So let's see, it went for my classes so far. First class had pretty good turnout. Second one didn't have anybody show up in person at all. I was just talking to a computer the whole time. And then third one had two. So this might just be need to go in and we're moving into the exclusionary rule. And
Is that 7? Chapter 7?
Yeah.
6?
Oh, I'm in the wrong year. I was like, where the heck is my course at? I don't remember the numbers. I just remember we just finished up with hearsay stuff. So that would be chapter 9. I haven't put it up in here. Let's do that really quick then. Chapter 9. Boom. Drop that right there. Back here. I'll actually bring up another one of these. So it is official 1 o'clock. And I hope everyone is having a great day, the last day before spring break or fall break. It all turns evidence. Yeah. Same thing, different semester. Let's see, 6, 7. Wait, that jumped way big. There we go. 9. Chapter 9 will be under this one. Here we go. Gonna download these real quick and then I'll pop them up in. Yep, the exclusionary rule. So we're moving off into some fun stuff. BPT. Okay, that downloaded. And then we'll pop it over here for everybody real quick. File. This is going to be chapter 9 outline. Chapter 9 outline. And so I was saying last time, the exclusionary rule, that's really what gives your Fourth Amendment rights any teeth at all. And so this stuff is very, very yeah, or PPF, PPT, all those letters. All right, so that's up there now. And I will also do the following. Share screen. That's my screen. We've got just where is that at? Downloads. That's where it went. Everything went to the downloads. We'll bring that up in case we want it. And we'll do this one too. I'll probably run through the outline first and then go back through and see what this has in its PowerPoint because I know it's one of those things that I'll like it more if I probably go this way. Because we'll start as we'll talk about this a little bit. All right. So listen. This is all Fourth Amendment. Some textbooks will kind of blur this between the Fifth and Sixth Amendment issues related to hearsay, counsel, your self-incrimination right as well. Is different though. It's not the same thing. The exclusionary rule itself is strictly Fourth Amendment stuff. The biggest difference there is when you start getting to that derivative evidence. And we'll talk about that in a second. Basically, when we were talking about confessions, if in the process of getting a confession, you identify where I can find other evidence, I can go after that evidence, whether or not that confession is valid or not, because I just have to have a legal reason to be wherever it is and be able to see it, something of that nature. So it's really easy to do that. The Fourth Amendment stuff, though, As soon as I have had that break, once that violations occurred, anything that's related to it whatsoever, all of the importance, all of the emphasis goes on to, you've got a constitutional violation. That's what matters the most. And so that's why we kick it out. Historically, if there were a Fourth Amendment violation here in this country, say someone kicked in your door, came in and they found you with whatever, they would still charge you with it. You would still face those charges. You'd have your day in court and you might be convicted. And as we go through this, I'll tell you some of the cases in here that deal with that kind of stuff directly. And so as this picks up, it says origin, derivative evidence rules, exceptions to the rule. We'll just start with that. So originally it starts out here and it lists out 3 cases here. It actually goes quite a bit before that. So when we're talking about it, this is just keeping evidence out of the courtroom, or it's going to be Fourth Amendment stuff more than that's what it says. Weeks versus United States is actually one of the not second cases, but probably the biggest one for instituting this as a rule, but not the one that actually does it. Some of the earlier cases that you're usually into whenever you start talking about this are the ones that define what probable cause is, because that's the threshold we always have to get through anytime that we're trying to bring anyone into the system. You have to have at least done something that's more than likely criminal. Because if you don't cross that threshold, we don't bring you in. That itself was a big change. Weeks, what it did is it was a federal case dealing with federal officers. And so I think I mentioned last time how the parameters of the case that go through and set the rule are the parameters that apply. And so what ends up happening is over the course of time in subsequent cases, they build off of that and it develops into a few different directions. Typically what will happen anytime you're doing really with Supreme Court cases, most court cases, Supreme Court cases where it happens on the biggest scale, you'll either have cases that distinguish themselves, as in for some reason there's something about this situation, this context or something related to that separates it out from the way things have already been handled. Every now and again, they'll come through and they'll overrule a previous holding or stance on an issue. That's much more rare. Usually that only happens whenever you start moving into like new technologies and that kind of stuff, which to some degree is part of this too. So it was a federal case, the federal level. And so whenever it was instituted, it only applied to federal cases and federal officers. Following weeks, they had a time period they call the silver platter doctrine. Basically what that was is if I have federal charge and it was Fed officers were the ones that had violated somebody's rights. Right? They're like, no, you don't get to do that. You can't use that to get the evidence to support the charge. So they did this. Same. Right? And so I want to say this was 19 teens, somewhere between 1910 and 1920. The next case that is going to be between Mapp and Ohio, hold on one second, between Weeks and Mapp, case that ended the silver platter doctrine. I can't remember the name of that one now. But basically what happened was because we couldn't have federal officers doing it, we started using the state officers. You remember that this is a system that is decentralized. So use that to their advantage, right? You have that break. There's no clear command here. That's just someone doing something of their own free accord, right? If you're doing it on your own, that's voluntary. I'm going to stop your volunteer work, right? That's the kind of the argument that was put forward to us. That's the basic principle. They came in and they dealt with this. Weeks, or was it? I'm drawing a blank. Was it Weeks that ended the doctrine or started it? I think it was the one that was either ended or started. I have to go back and look now. I want to say it was the one that started it. Weeks first, but I did go back and look. They start handling it this way. So the next case they had to go and be like, no, this doesn't work either. Right? And so there's a case where ended the silver platter doctrine, but it didn't deal with the fact this is only at the federal level. Right? That's where MAP comes in. And so when MAP comes in, MAP is the one that says, it doesn't matter if we state or federal. So they literally had to walk back federal level, federal officers, federal level, state officers, federal, no, we'll just go straight state level. That happens. So now it applies more across the board. But if you think about it, the underlying principle there is still the same. So long as you are not directly agent of the government, this doesn't matter to you. If I go and I kick in somebody's house and I find somebody's door and I find that, there's a kidnapping, something like that. That doesn't matter. They're going to get charged at whatever level because I'm a citizen. I'm not bound to this. And so that's the big thing that it did is when MAP went through, is it bound us all of this, basically any officers, whether state or federal. MAP itself, you read the case before. You read the case before? Okay. It's really an interesting case. So 1960s, I'm starting to think Weeks might have ended the silver platter doctrine. That's going to drive me crazy because I should remember that off the top of my head. MAP versus Ohio, that's one where it was basically it was police officers thought that MAP, a female, was harboring a fugitive in her home. If I remember correctly, I think it was a bank robber that they thought was in her home. They approached her home, they knocked on the door, they asked for permission to come in and look, and she said no. Got that right. No, you can't come in, sorry. Okay. Well, when that didn't work, she actually called the lawyer at the time, and the lawyer advised her lawyer advised her to say no to them. So she was on the phone with counsel to make it a little bit more complex. Police leave, and they come back some time period later. I think it was a few hours. This time, they say they have a warrant. They're waving around a piece of paper. As they're saying that, she, I don't know if she asked for it or not, but she at some point snatches it out of somebody's hand to take a look because she doesn't believe it. And rightly so, because it was fake. And so with that case, they actually tried it a couple different ways. That one was one where you have that underlying element that it's passed. The other issue was false pretenses. Can someone consent to a search if you're providing those types of contexts, right? I'm providing you with this evidence right here. I have a warrant for so-and-so's arrest, to search your house or whatever. Right? I'm not going to give that to you. I have it right here. Basically, whenever you start presenting situations like that, you've invalidated anybody's consent. They just cannot do it. Yeah. It's like, how am I, if I say no, you've got the paper anywhere that says you can come right in, right? If I say no, am I now resisting arrest or resisting this or obstructing or interfering? And so you open it up. With her, she grabbed it to take a look. It ended up being a little bit of a roll around kind of brawl kind of thing. They ended up arresting her and they searched her entire house. They found nothing save for some lewd pictures. And they charged her for that. And so that's why you get this. Because after all that, all of those violations there, all that those persons' rights just being stepped on, and then on top of it, you're going to face this. It's like, not only did we just violate all your rights, but because of the fact that you try to act like you actually had those rights in the first place, well, we're going to make sure you go to jail for a little while. It's like, no. The exclusionary rule that passed in the 1960s, it was a 5-4.
It did say online, I did look it up, and so we had these around it in 1914, and it said, the silver platter doctrine was a rule that allowed state officials to do.
So it started it.
Who could then use it in federal courts. Silver platter doctrine were unconstitutional in Elkins versus US.
Elkins, there we go.
1960.
There we go. Yeah, that's what I couldn't remember. I was like, I knew that there was another one in there. I couldn't remember if Weeks started it or if it stopped
Yeah,
it. The
so-
Elkins, I knew it was like, 50 years later. So for half a century, okay, let's just grab a local officer. right? That's what that is. That's pretty serious if you think about it. If you think about the way society is shaped now versus then. Things were definitely much harder back then. It's just, yeah, they're gonna hit you no matter what. And so that one was in the 60s. Matt came in right at the end of the 60s. The best part was is since it was a 5-4, very, very much consent not controversial, that's the word. And so the biggest part of Matt versus Ohio, so it starts moving towards the street. So I'll talk about it for a second before I get into that. Actually has to do with that let's see what was it? It was the consent element and the fact that your consents need to be both voluntary and intelligent. That kind of thing. Ooh, I'm going to two things. So when you look up, it's unrelated to anything that's probably in this one. Dixon versus United States, and that's going to be all the way in the year 2000. Okay. This one's a blur between a little bit of the exclusionary rule and your Fifth and Sixth Amendment protections. So Matt and versus Ohio was a split, and so was Miranda about the same time period. Miranda's the one that they actually made a congressional action relating to. I think I mentioned that in class before. This is a case that came up 40 years later, where they were trying to get in someone's confession invalidly. They were trying to overrule the Supreme Court. The Supreme Court says your confessions need to be both voluntary and intelligent, so you need to be warned. It's the same thing for the waivers for your Fourth Amendment, but they don't have to notify you first. That's the only difference.
Like the can will be held against you part?
No, they don't. They don't tell you can say no at all. Yeah. So the way they present it, they can make it look like they can infer that you don't have a choice. How's that? They can't say that you don't have a choice, but they don't have to tell you you don't. And so you can play with that context enough to make it feel like someone has no choice. That's why so many people consent to a search. It's like, dude, you didn't have drugs in the car. Where you say yes? That's why. And so in this one, they tried to bring in that congressional act that got passed 40 years beforehand to let someone's unconstitutional confession come in. Supreme Court actually had to sit down and rule on that and say, no, Miranda is a constitutional rule. It is the embodiment of this right here. Why do I bring that up now? This thing right here, get rid of this. This exclusionary rule is not a constitutional rule. It is only a judge made. I don't want to say that. Right? And so what that means is it was just within the purview of the courts. Source statutes, kind of similar. So here in this situation, this allows Congress or something like that, if they wanted to try to weigh in on it, the door is open because it's not been ruled a constitutional rule. When it's held as a constitutional rule, then it's solely within the purview of the Supreme Court. So this whole thing where we don't have police forces that can kick in your door, searching for anything that they can find that's criminal and hold you against it, is only in place because of this right here. So with a single congressional act, you do have the entire society revised overnight. And you have your forces of people coming through, kicking in doors, and putting people wherever they like. That's how dangerous it is. That's if they do that, you have those kinds of actions. People start talking about it. What would happen? You'd have a Supreme Court case that would come up and they look to see, do we want to make that a constitutional rule? Ideally they would, but who knows? It's just people. It's all just people. And so that's a huge, huge danger that no one really talks about. That's just right off the start. Hudson versus Michigan, I don't remember. I should remember that one. I don't. But I'll skip that one for now. If you want to look it up, you can. I don't remember that. But we'll jump into the derivative evidence stuff. And so that's what makes this different than Miranda. Well, there's a few things here, but that's the biggest one. This derivative evidence. And so basically, the case that had to do with this one, I got a couple chats in there. I can't see. Let's see what that is. Oops. Gee, it's the Fourth Amendment. Yeah. Yeah. Why does the exclusionary rule give teeth? Could I expand on that? That was a little earlier. I talked about that one a little bit. Just double back on that one. Basically, it's the only reason why evidence of your criminal wrongdoing can't be used against you if it comes into the hands of authorities, right? It's one of those interesting things. Usually what I'll do is if I have more time, I ask the question, maybe I've asked it here. Does a police officer's wrongful actions negate your own criminal wrongdoing? Like, no, it doesn't. Someone else did something wrong, so the fact that I was doing something criminal is better? No. It's just we put so much more weight on the fact that those authorized by the government, it's their authority. You've got to regulate that. That's of the greater concern than the person who's doing the wrongdoing. Because if we do that, that's that Blackstone formulation, if you really get down to it, where it's the value of freedom versus the value of confining everyone. We run that way. It always ends up where evil power takes place, always. And that's, if you look across history, it's like that's what you see over and over and over. Derivative evidence with this one is a no-go. That's going to be case by the name of Wong's son. Wong's son versus the United States. Could be an officer's name, I can't remember. Basically, what happened here was a whole bunch of people's rights were violated. If you were to read the case details itself, basically what happened was it was I want to say it was a heroin drug thing. Can't remember the exact drug, but it was a drug trafficking kind of thing. Police officer trying to find someone who was trafficking drugs, had a nickname by the name of Blackie Toy, associated with some type of it was like Chinese laundry or something like that. It was, and in doing so, they violate that person's rights. They get a whole bunch of evidence against this person, which they really didn't have any reason to search in the first place, kind of thing. That person identifies another person. They go and violate that person's right. And by about 3 people deep, then they finally find someone who's actually done something wrong. But we've had so many breaks here in what was right and what was wrong that it becomes a really, really big issue, because by the time you're done with this, you had, I think it's like 3 people that had unworn confessions. You had all of the tangible physical evidence that they had acquired, bugs, and that kind of stuff. It's like, what can you use and what can't you? Well, the fact you violated all their rights, at least at minimum, the right to be free, and you searched them for no reason and moved on from there. Yeah, everything wasn't able to be used. What they did was they did this. We're going to take this. I'm going to ignore all this. I'm going to release you for some period of time. And at that point in time, basically what will happen is they reproached them, asked them to talk about their previous unworn confessions, right? And so with that break in custody, they're talking about what happened when their rights were violated. They're again admitting to what they'd already talked about, because they didn't realize that what they'd already said wasn't going to be able to be used against them. And so now they found a way to get the evidence they could. But a lot of work involved, a lot of evidence lost, a lot of things like that. When you start looking at So that's about what derivative evidence is. And so you have that initial error, whether it's a violation in search procedures, arrest procedures, that kind of thing, or technically it could be you were in a place you shouldn't legally be if you're an officer. That's kind of has to do with search stuff with officers. You have that break, you can't use any of the evidence related to it, and anything that comes off of it unless you have a clean break. And that break in custody is one of those types of things. When it comes to exceptions, there's a few exceptions to this rule. All right. And so the first ones that you probably need to go through, this one list exigency, because that's one that's always there. I'm going to just start with that. Exigency, again, is just emergency situations. It is the big excuse for everything, right? We're in an emergency. Okay. Rules don't apply to some degree. All right. So we have independent source, inevitable discovery, good faith. What am I missing? Good faith. No. What does it have over here? Inevitable discovery, independent source, attenuation, passage of time. That's got to do with that break in custody. So there's another one I'm forgetting. All right, so exigency, that's just basically an emergency. These last three are a little bit different. So independent source, inevitable discovery. Let's start with inevitable discovery. That was a little bit more straightforward, right? Now, if you really want to get in the cases, I want to say that one might be, I think that one might be the Christian burial case, was commonly referred to as. Basically, what had happened was murder case. Murderer was being transported by police officers a good distance. I want to say it was like from Des Moines to another place in Iowa. Basically, what had happened was I already had a witness there that said that this person had a body rolled up in it was like carpet or something like that. Kid actually kid sees his feet sticking out, kind of thing. So it's like, yeah, you kind of know what's going on. In the transport, you're not supposed to talk to the guy. You already asked for a lawyer. This isn't an interrogation. His lawyer is not present. All of those things. Well, in the process of traveling with that person, officer struck up a conversation. In doing so, that suspect told him exactly where that body was, where she was. By doing so, you can't use that. Ooh, that's so horrible. Because that's a really vital piece of evidence. What happened to her? The way they were able to get it in was they were still searching for her. And in fact, if I remember correctly, there was something like in the same field she was found, and they were heading that way at the time. And so beat them just by a few minutes, kind of thing. And so at that point in time, yeah, you had a violation here. We're gonna find her. You're not going anywhere. You're here. You're not getting rid of it. You know, that's how it works. Probably the next one I want to talk about would be good faith, because independent source can be a little bit questionable.
There was also a continuation of the team.
Yeah, so that's gonna be one of those things where that time element of it, that's 14 days. That's that break in custody. That's exactly what that's gonna be. That time element, that's the clearest way to do it, is if you've got some way to release them and some way you can have that time and reapproach. The only other way would be have them reapproach you. And that's much harder to do. But you can do it. Harder to do. So good faith pretty straightforward, so long as you're not doing anything with bad faith, you're not trying to purposefully infringe on someone's rights or do something you know you shouldn't be doing. As a general rule, you're pretty good. This has to do a lot with like errors, like technical errors and things like that. You get your subpoena. We'll say it's no, we'll say it's an arrest warrant. Search warrant. We'll say it's a search warrant. Drug traffickers, residents, or something like that, right? Arrest numbers off. Oh, you kick in the wrong door, right? Should you have known? Maybe yes, maybe no. If not, that's not your fault, right? Another error would be like when you get in, you actually look at the warrant itself. This is something they actually have some trouble with. And they recently, last couple of years, those types of courts had some trouble with it. And your warrant is found to be defective because it doesn't actually have probable cause. The officers that went and effected that search, they were still acting in good faith. It's not their duty to make a determination as to what the judge had made. So if the judge found, or magistrate, whoever signs off on the warrant, found there to be probable cause, that's not up to the officer to question. They just have to run because they're the authority. They're the judges on that one. And so you can have errors, whether it's in addresses, related to the fact of whether or not you have probable cause itself. So long as you are acting in good faith and you're not doing it on purpose, it's good. So if you have that error on purpose because you think that this person's, their address is just a couple numbers off, but they're also a drug dealer or a drug trafficker. And so you did that on purpose and they can establish that, that's not going to be able to be used. What would be another example? Be like, here's a good one. We're talking about who could consent to what special relationships, husband, wife, domestic. I used to remember the name of the case, but I don't. It was a drug one. Trailer, female and male were both present at the scene, right? They're trying to deal with this dispute at the same time. Wife's trying to get stuff. She comes back out. Officer stand outside with this male. And by the way, there's a whole bunch of drugs inside. Ooh, okay. Can I go in? She says yes. He says no. The no stands. Right? You can't just go in. Now, if I were to go and place that person in handcuffs and take them to the station for whatever reason, and then turn around and ask the wife again. She says, yes, I'm not getting the no anymore. I could go in, but that wouldn't be in good faith. That would be I did that on purpose. If something else happened, like in the course of how they handled that one was they just stayed right there while they went and got the warrant. And so that's pretty easy to resolve that. But if it was something like, let's say, showed up there, it's a domestic thing. As things are kind of breaking down, let's say, guy already had a warrant out for his arrest. They throw him in the back of the car and then ask. That's good to go. Because that wasn't them. They did not do that on purpose. That's not their own doing. And so that's good to have that in there. This one is interesting. Independent source, how that one works. You do it on time. Oh, it's like I thought it was going faster. That one's, if there's been some type of error that's taken place, we can still establish probable cause some other way, then it can be good to go. This one, the case details for that one was it was drug trafficking. It was related to a warehouse and I think it was semi trucks that they pulled over. So they'd been watching. They knew what was going on to some degree. Had probable cause to pull the vehicles over. They pulled the vehicles over. Found the drugs that they had found. So they had everything that they needed to be able to identify the fact that we need a search warrant for this warehouse kind of thing. So that way we can identify that main distribution point and secure those drugs. They did not do that. They went and broke into the place first to make sure the drugs were there. Yeah, that's not so good. That's like Okay. That's why this one was kind of questioned. If we can establish probable cause, some alternative way without that violation, that is a better way of handling. However, a greater corrupt question gets to be asked at that point. If you're already in violation of what you know to be your policies, practices, and those types of things, and you know that this is a violation of that privacy, what are the things you're willing to violate? That's a dangerous one, right? Because at that point in time, it's like, yeah, you verified the drugs were there. You didn't take or touch anything, right? Right? But you already touched stuff. You already went in there. Why'd you do that? Not the best way to do it. But if in case something like that happens, they have an exclusion for it or an exception to that exclusion. Miranda. So here's where they start talking about. Okay, so there's this. I don't like this so much. So that makes these things up a little bit. Miranda doesn't work that way with evidence, that kind of thing. It's yeah.
Like your Miranda rights. Right.
In terms of if you have a Miranda violation, as you talk, those words cannot be used against you. It can still be used to guide investigations. So long as it doesn't enter into the courtroom, there you go. Right. With this thing, it's like you use any of that. That's it. You're done. Right. If I have a violation here of your Fourth Amendment rights and I can't clearly identify an exception for it, that's not going to be good. You don't necessarily have to do that with Miranda. It's you got too many loopholes there, is what it is. Yeah, that's basically what it is. You start getting off to the poisonous tree. It doesn't necessarily work the same way. This one has a hard block. So as long as you've got that violation, anything that's associated to it. The same thing with confessions. If it identifies where other evidence can be found, yeah, you go after it. That kind of thing. The next thing we need to talk about, knock and talk. There's knock and announce, knock and talk. There's talking with people, and there's gathering information. So it's like, you got like 3 different threads that are really sewn together real tight here. So we're going to deal with the exclusionary rules side of things, the Fourth Amendment side of things. Knock and announce is probably the first thing you want to talk about there, because you have to have that approach to the door and entry. Depending on the danger associated with it, they'll skip that, right? That's the no knock warrants, that kind of thing. Which is always one of those interesting paradoxes, because there's more danger here, we're going to do something more dangerous. Sort of like whenever they're dealing with police chases. We start a police chase because they're dangerous. When they get too dangerous, we stop chasing them. I guess I get it. But this thing, not gonna announce, or not in announce yet. Huge subject to debate, because that's something that by default is not, warrants are not, no, not warrants. All of them are knock and announce, unless you get a special exception, you apply for a no knock warrant. What happens though if you have a regular warrant and you choose not to announce?
And knowingly, would that go against good faith?
Mm-hmm.
Yeah.
You're gonna get in some trouble. But it's not gonna affect any of the processes. You'll just get in trouble with work, right? Because that doesn't change whether or not you had probable cause. It doesn't change the circumstances in which you entered, that you gathered the information. It just, you weren't nice about how you did it. That kind of thing. So it's one that those violations don't necessarily enter into this area. You start looking at the knock and talk kind of thing. So that's where you get some really interesting stuff. So that's that territory where you get to our police officers people, right? Anybody can walk up to your door, knock on your door, say hello, that kind of thing. Police officers can too. That's the knock and talk element, where you start getting to some interesting things. Maybe this book might talk about that. Some of the crap that people pull doing that. Right. While I come up and knock and talk to you, I'm gonna bring a drug dog with me. Right? Something like that. And so at that point in time, you're going beyond. you know, there's other ways you can go on, like technology is another way. Good example is, can't remember the name of the case, I want to say it's Kylo, K-Y-L-O-O. They were taking a temperature gauge to people's houses. How warm is this house, right? That one's too warm. That one's growing marijuana or whatever, right? Using that, you've gone into the exclusionary rule territory. You violated that person's rights to try and figure out what's going on inside their home. And so it's the same thing as being there. That's the big thing about the officer side of it, is making sure that you're standing somewhere that you're legally allowed to. It's a public place or someone's front porch or something like that. Those are all normal things. To tell you to leave, you should. But when you're standing in places where you shouldn't be, that's where basically start moving that plain view kind of thing. I won't talk too much about that because this doesn't go into it. But that's where you start getting to whether it's readily accessible. Is it readily apparent for what it is, kind of thing. So knock and talk. You can come up to the door. You can talk to people. Just make sure you're not trying to violate their rights. You're not trying to get inside their house, and you don't do anything that would cross those lines. From there, state's covered by 2 exclusionary rules, federal and state. Yeah. Let's see what this says. For a poisonous tree, if constitutional police conduct leads to discovery of evidence. Yeah, that's pretty short. Not going to announce serving. Search warrant, Michigan for Hudson versus Michigan. Okay, so that's got to do with the amount of time. That time element. Whenever you knock and announce before you break in the door. That's one we should probably talk about real quick. Basically what that is you need to give that person what would be sufficient enough to be able to answer that door, right? It's not a knock, 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 police, boom. It's not 30 seconds either. It's just a few seconds. It's in the ballpark figure 15 to 20, something like that. Because what you start dealing with pretty quickly, if you look at the cases, is you take too long, you're either going to start hearing flushing or you're going to feel a nice breeze coming through a window, right? Because they're going to try stuff like that most of the time. Let's see, what else is on here? Non-exclusionary rules. Let's see what the PowerPoint says now. Okay. Move slower. Okay, define derivative evidence. Yes, that's evidence that's a direct product of whatever action you take. Exception exclusionary rule with the entail to cover that. Oh, state the role of exclusionary rule for evidence obtained by an improper search. Yeah, some of that's framing stuff. That'd be like talking about how this stuff worked before we put these rules in place. State the role of exclusionary rule evidence. Yeah. Okay. Incriminating statements made in the process. And we kind of talked about that one already. Due process. Discourage improper illegal investigative procedures by law enforcement. I will take this as a quick second thing. The history of the exclusionary rule is a long one. As a general rule, if the courts have to institute a rule like this, it's because the behavior was so widespread that they had to. And that's what was going on with this one. You can find all kinds of interesting cases related to this kind of stuff. My favorite one I ever read was in the late 1800s, where it was a sheriff or a police officer, evil, that was trying to kick in somebody's door and murder them. They got shot and killed in self-defense. The person was let off for it because it was just a completely different time frame. They could establish that kind of stuff. But yeah, the behaviors there were not necessarily what they need to be. Some of them are still allowable. Like if I was telling you about, there are cases where people cross borders or state lines and abduct criminals and bring them to court. And in those instances, it's has there been criminal actions that have taken place? Yes. But what usually takes place is that whoever was absconding from trial now faces trial, and we'll just take care of that first, that kind of thing. And so you'll find that, but that's going to be old stuff, probably 1950s kind of thing. Ooh, too fast. Constitutional rights threatened by misconduct, 4th, 5th Amendments, yes. Constitutional protection, security, yes. weeks in federal cases. Mapp versus Ohio, 61. I thought that was later in that. Nope, that's where they're talking about Elkins, 61. All right, Miranda, Dr. Rule, minimum safeguards must be used for obtaining possession or incriminating statements. Yeah, that's basically you have to Mirandize somebody. Whenever you look at Miranda, there's actually a few different elements in there. Let's see, what is it? In terms of your consent, both your aspects of your consent in there. At the very end, because they're supposed to ask, do you understand what I've said? Are you willing to speak? Those are your consent elements at the very end. It'll outline you have the right to a lawyer, right to remain silent, those kinds of things. Indigency clause is also in there. That's the one where they say if you can't afford a lawyer, so it hits your Fifth and Sixth Amendment pretty well. But yeah, without that warning, you functionally don't have that right at all. So that's why Miranda's important. Same thing with Mapp for the exclusionary rule. Yeah, that's just talking about enforcements and violations. Basically, what it does is it excludes evidence. Okay. Cool. So this is where they're talking about that good faith, where it's errors from a clerk, errors from judge, those types of errors. The only time that wouldn't fall under good faith was if it was done on purpose and the officer was purposefully aware of it, that kind of thing. The police in the case failed to check the arrest warrant, still valid, acted in good faith. So that's another one where there's actually a few cases like this. This one specifically, what happened was that the person actually came to the police, probably a ticket or something like that when they were doing the background on the person. They found that they had an outstanding warrant. But doing the background phone had an outstanding warrant. That warrant was no longer valid. They addressed where to find it, whatever it was. It's just the system itself hadn't been updated. When he saw that, he started to take that person into possession. I think he found a gun or something back in the vehicle. So that's why the case took place. There was another criminal thing going on there. All right, defendant moved to suppress evidence, claiming police failed to wait a sufficient time for announcing the present. That's Hudson. Yeah, that doesn't violate. It's not best practice. There you go. Preserve evidence for the poisonous tree. Talked about that. Discovery. Yep. Illegally seized from evidence. Okay, so that's a little bit about unwarranted confessions. So we talked about this. We talked about this in the harmless error. Harmless error doctrine. So it will apply for any type of violations. It's common in this one's a confession one. Basically, if there's been an error that's taken place, historically what would have happened was particularly with confessions, if you had an invalid one come in, they would have viewed that as invalidating the whole trial and you basically be released. I can't remember what year this took over. The harmless error doctrine, basically what it means is that upon appeal, if they find that there has been an error, they have to make the determination as to whether any actual harm has taken place, as in if the error itself was detrimental to the defendant. And so it's like in most of these cases, especially like confession, you think that's going to be a really, really serious one. Not always is though. And so they'll look at all of the evidence right there to determine whether or not it was harmless. If it was harmless, this decision stands. If they determine there was harm there, then probably been a new trial or being released, that kind of thing. And so that's going to be the judge's decision on appeal, which is different than, the jury to begin with, but that's, again, addressing errors within the system. Challenge directly, exclusively with one. Yeah. So not necessarily negligence. Independent source we talked about, independent source still, inevitable discovery. Yep, body was a short time without Attenuation passage of time. Significant period of time passes between improper conduct and new evidence. The taint can be dissipated. That'll be Wong Sun. I think it's Wong Sun versus the United States. If you look at the name Blackie Toy, that'll be the nickname that one of them had. It was one of the Wong Suns. They actually had the wrong Wong Sun, if I remember correctly. Fun. Yep, there it is. Wong Sun versus the United States. Illegal search. Improper conduct involves Fifth Amendment protections. Yes. Courts have been less consistent with applying poisonous tree doctrine there. That's why Miranda's different. State versus Knapp, murder trial was suppressed pre-Miranda, and the physical evidence seized. Miranda does not make exclusionary. Yeah, I think I covered all this stuff. Does not make exclusionary rule applicable. Physical evidence obtained from voluntary statements made without Miranda. That's the big part right there. All right. Here it's just going to talk about unlawful seizures. Does not apply to statements are involuntary. So if they're forced, then it wouldn't work. There you go. And so here's where they start breaking it out. 4 constitutional violations leading to committing statements and discovery. Physical evidence. Unlawful seizures, involuntary confessions, violations of your right to a lawyer, and not telling people that they have their Miranda rights at all. Okay, Michigan versus Tucker. Yeah, that's just involuntary statements. Knock and talk we already talked about. And here's what it mentions. All states must follow the maps, not a court states impose additional requirements. Right. And so that's going to be that overall framing structure. Federal is going to be the widest, but also the most relaxed because it's got to fit all the different areas. And so that's why I will mention that in there. And I think that should basically get us through this one. Yeah. Most other countries do not have an exclusionary rule triggered by police misconduct. That's huge. Why? Most other countries have huge issues with corruption and power. We do too. That's just we try to address it sometimes. Maybe used to address different kinds of violations of individual rights. Yes. Yeah, it just talks about the future. Future I see. If it's a good one, we won't have to worry about that thing I said before, where it's they start to bring that into question, and we have to see if that becomes a constitutional rule. If it does, there's gonna be a time period where we don't know. That will be scary. That would be very scary. We wouldn't want that. But with that gets us through here today. Any questions or anything? All right. Well, with that, I will tell you all have a great fall break. Have a good one. All right. Catch you next.